questions, and we're running out the clock. The Washington Post reported that, quote, the Vice President's lawyer, referring to you, I believe, advocated what was considered the memo's most radical claim, that the President may authorize any interrogation method, even if it crosses the line into torture, unquote. Is that accurate?
That the Washington Post said that?
No, not that the Washington Post said it. Is the Washington Post correct in saying that?
Could you repeat it? I have to listen closely.
That you advocated what was considered the memo's most radical claim, that the President may authorize any interrogation method, even if it crosses the line into torture.
No, I don't believe I did advocate that. What I said was, in the meeting we had with Mr. Gonzalez and Mr. Yu and me present, Mr. Yu ran through, here are the topics I'm going to be addressing, one of which is the constitutional authority of the President, separate from issues of statutes. My answer is good. I'm glad you're addressing these issues.
So in other words, you didn't advocate any position. You simply said, I'm glad you're going over these topics.
Correct.
Okay. Now, do you believe that the President can order violations of the federal torture statute if he believes it necessary for national security under his Article 2 or any other powers?
I'll answer that carefully, because although in common conversation we're used to using words like torture and meaning a common conversation, what we're talking about are laws here. There's a federal statute which implements a treaty.
Well, let me just narrow the question. Do you believe the President can order violations of a federal statute if he believes it necessary for national security?
As a general proposition, no. I qualify with as a general proposition because I think we all agree. In fact, there was testimony here, and I think some of the members of this committee agreed, that facts matter for lawyers in rendering opinions, and I wouldn't render a legal opinion in the absent. I wouldn't render one of the committee in any.
Well, when do you believe that the President is justified in violating a statute?
And you're assuming a fact not in evidence. I didn't say I did believe that.
You said under certain circumstances.
No, I said reserving the fact that you need to have facts in order to render legal opinions.
Are there any set of facts? Excuse me.
As we said,
is there any set of facts?
Mr. Chairman,
is there any set of
rendering a legal opinion?
Is there any set of facts that would justify the President in violating a statute?
I'm not going to answer a legal opinion on every imaginable set of facts any human being could think of, Mr. Chairman.
Do you believe that the torture of torture, never mind how you define it, assume it's torture. Do you believe that torture of a restrained detainee could be allowed under a theory of self-defense or necessity?
I haven't expressed an opinion on that, Mr. Chairman.
You have not expressed an opinion. Do you have such an opinion?
I haven't researched the issue myself. I've relied on opinions on the subject issued by the Department of Justice.
Well, you did express the opinion, I believe, that the President could, or that his Article 2 powers as Commander-in-Chief, in effect, allowed him to take actions which the FISA statute would prohibit. Is that correct?
I don't believe I've expressed those here. I think there is a serious question, constitutional questions raised to the extent Congress, instead of helping by passing statutes to carry into execution the President's power, would instead try to block the President's power. There are court cases at the circuit level, not at the Supreme Court level, and also the Foreign Intelligence Surveillance Court of Review that refer to the President's Commander-in-Chief powers as including.
All right, let me ask you one further question. Let me ask you one further question.
Mr. Chairman, I'd ask unanimous consent to grant the Chairman an additional minute to complete his questioning.
Thank you. Without objection. Mr. Addington, Mr. Yu, Professor Yu was quoted as saying that under certain circumstances it would be proper and legal to torture a detainee's child to get necessary information. Do you agree with that?
I don't agree or disagree with it, Mr. Chairman. I don't plan to address it. You're seeking a legal opinion, and as we told you in Exhibit 4, I'm not here to render legal advice to your committee. You do have attorneys of your own to give you legal advice.
What? Well, he just said he wouldn't give me an opinion. The time well, let's see, I have half a minute yet. Let me ask Mr. Yu one question. In your memo, Professor Yu, you talked about, in the memo that's been quoted repeatedly from August, or the Bybee memo, which you helped prepare, that severe pain, as used in the federal statute prohibiting torture, must rise to the level that would ordinarily be associated with a sufficiently serious physical condition, such as death, organ failure, or serious impairment of body functions. Where did you get that from? I mean, I know that language is in a different statute, but where did you derive that that's what torture means under the federal statute?
Well, Mr. Nadler, Mr. Chairman, you're referring to the August 1st,
Yes.
2002 memo, not
Yes.
the
That's a quote
March
from the
2003.
Yes.
I want to say your question is where did it come from?
No, how did you reach that conclusion? I mean, you made a very specific statement that this is what, that in order to violate the statute, it's got to meet this criterion.
Yes.
Where did you get that criterion from?
So let me make clear that when Congress passed that statute, there's no further definition of that phrase in the statute itself. We looked at the legislative history. There was no legislative history from the time of the passage of the statute that produced any kind of definition. There was no, the United States Justice Department had never brought a prosecution under the statute, so there had been no judicial decisions of that language. So we applied, I think as the memo says, a canon of construction to try to find anywhere else in the U.S. Code where Congress, where you have defined those terms in any other kind of statute. And as the opinion says, and the 2003 opinion also says, we recognize that that statute was not, was on a subject that was different than the torture statute, but we used a canon of construction to try to infer from what Congress has passed in other contexts to see if it can provide some help to us in trying to interpret what I think I think that was a very difficult statutory language because there was no further judicial interpretation or congressional guidance.
Thank you. The time of the chairman has expired. I'll now recognize the distinguished ranking member on the subcommittee, Mr. Franks.